right, good afternoon, everyone. Go ahead and call our meeting to order. I want to thank you so much for coming to my first meeting as the president of our association. I'm excited. Thank you. Of course.
Nothing to do with anything else.
You know, my goal for this year is to have informative programming, and so we have a series of speakers. Goal is to have 10 or 11 speakers throughout the year, especially allow all of us to get CLE credit, learn about areas of the practice that are perhaps outside of our comfort zones, really help improve the practice of our bar and in our court. Before we get started with today's speaker, I want to just make a handful of announcements. Thursday, November 5th is View from the Bench in Tampa. It's at the Sheridan Suites, which is out by the International Mall?
West Shore area, off West Shore, Cypress.
Okay. Judge Delano will be on the Tampa panel, and so I'd encourage you to attend that one. I don't think she's making the trip to Miami this year, but if that's more convenient to you, Friday, November 6th is the Miami panel. The night before the Tampa, there's a reception in honor of all the judges that are participating. It's being hosted by the Tampa Bay Bankruptcy Bar Association, and that's at the Le Meridien Hotel. I've sent around an email with all the details about both, but if you need more information, just give me a call or send me an email and I'll get you what you need.
It is hosted by the Bankruptcy Bar, but there is a charge to attend. So, but if you're going up the night before, it's a really fun event.
I think it's $50. Okay. And then our next meeting will be Thursday, December 19th, here in the jury assembly room at noon. For that meeting, we'll have Robert Elgadelli of Genovese, Joblove, and Batista. He'll be our presenter. And he's going to present on the amendments to the rules of civil procedure that are going into effect on December 1st. And their applicability, particularly the case management amendments and the discovery amendments. And so how they'll apply and affect your practice, also give you some suggestions, best practices with respect to discovery in your contested matters and adversary proceedings. Okay, and today, I'm very honored to have Sanit Kapila and Melissa Davis from Kapila Mukamal LLP. It is a full-service litigation support and solvency firm located in your office just in Fort Lauderdale?
Fort Lauderdale in Miami.
In Fort Lauderdale in Miami. Sanit is a panel trustee in the Southern District, and he's also had occasion to administer some cases that I think have been particularly interesting, exciting, some might say juicy, including the Perlman case, which was an $800 million Ponzi scheme.
About $500 million, yeah. 500
$500 million. So I embellished a little bit. And so without further ado, Sanit Kapila and Melissa Davis.
Thank you very much, Louis. I appreciate it. And thank you, everyone, for you all to be coming here, and we appreciate the invitation. We have a small group. My mindset is or was that I will try and touch on some aspects of tax practice pointers for the consumer bankruptcy side. I wasn't sure what the audience will be, but Louis had mentioned that they can be trustees, fiduciaries, and attorneys who practice in that area. So it just occurred to me there may be some take-home practice pointers worth being mindful of. And then we will split it into another part of the presentation where we may talk about some cases and the challenges we have faced in the kind of cases, whether they're in the middle district or in the southern district, where I may have been involved or my firm may have been involved as a fiduciary, whether it was a trustee or a chief restructuring officer, but more importantly, what were the major encounters we come across and the dilemmas we come across and how we try to conquer those landmines and challenges, which is normally the hard part in many of these cases. With the small group, I am not looking for this to be structured in any way. If you want to raise your hand and just say you have a question, don't hesitate to stop us, and we will shift gears and try and respond to whatever the question may be. A greater focus of my tax consideration is going to be more in the Chapter 7 area, although some of them also apply to Chapter 11s oftentimes, and they would be to a greater degree affecting individual bankruptcies. I think when debtors file bankruptcies, the starting point is with the debtor's lawyer, and disregarding the fact that the trustees encounter, I don't know if it's 92% or 97% of no asset cases, the opportunity to plan for any tax issues that a debtor may encounter is at the time that they consult with the lawyer at that time. And they have to do with what is often referred to as the short year election, and is sometimes referred to as the Section 1398 election, and that section references to the Internal Revenue Code. Keep in mind that when individual bankruptcies are filed, unlike a corporation, there is a split tax year. The individual pre-bankruptcy has his own tax year, which begins at the beginning of the year and can be split if he chooses to the point of his bankruptcy petition filing, or it can be his whole year, however the person chooses to proceed. But from the petition date onwards, there is a new tax year that the trustee gets involved in, and the events that occur after that petition date are the events that will generate the tax consequences within the bankruptcy estate. And the assets of the debtor from the petition date as listed, and perhaps if they are unlisted but property of the estate, so to speak, property of the estate will transfer to the bankruptcy estate under the supervision of the trustee, and some of those assets will generate tax consequences, some will not. Now, importantly, there is no tax event when the debtor's assets actually shift as property of the estate into the bankruptcy estate. At that time, there is none. And equally, if a trustee abandons an asset, the abandonment, as a general rule, is back to the debtor. And that abandonment itself also does not generate a tax event. The abandonment transfers the asset back to the debtor, and there is no tax disposition there. So the trustee has to actually inherit title and actually do something more affirmative as to a disposition. But a return of an abandonment is excluded from as a taxable event. So a debtor has the opportunity, if you have a debtor who has income in the short period, let us say from January 1 to April 30th, or June 30th, and he has taxable income, and the debtor has what is known as tax attributes at the beginning of the year, effectively the end of the preceding year. Those tax attributes by law would transfer to the bankruptcy estate as of the preceding calendar year beginning, or rather as of the beginning of the calendar year in which you file bankruptcy. So if a debtor has $50,000 in net operating losses, to use a classic tax attribute, that becomes property of the estate even though he or she files bankruptcy on April 30th, but his NOL carryover from the former year was at January 1 of that year. Now, how does he or she choose to benefit from that net operating loss? If that person has income, heavy income in those 4 months, and believes that that income will incur a huge tax liability if he or she files a full year tax return through the end of the year later on, that person can elect under section 1398 to split the tax year and make it a short year for him or herself for the first 4 months and utilize part of their net operating loss to offset the tax liability. That's where the tax planning opportunity is for the debtor. And then any leftover unused net operating loss would flow into the bankruptcy estate. And that is an often ignored aspect, because if you don't do it at that time, it's too late to go back and retroactively elect to do that. And the election comes in with an extension period depending on the tax return you're talking about. So that is a useful pointer to watch for the election and consult with your advisors as to how to actually effectuate it. Of course, it applies to someone who has the operating losses and has the income to offset it. Generally, with net operating losses, there are other tax attributes. You can have tax credits, all sorts of attributes which actually are always property of the estate as of the effective date of the beginning of the calendar year of the bankruptcy. And if there are ever unused tax attributes at the end of the administration of the bankruptcy estate, they revert back to the debtor if he or she has value for them, except for any losses that are generated resulting from the administrative expenses of the estate. If they add to the losses, they do not revert back. That component doesn't. The rest of the losses which came in originally will revert back.
Does the Chapter 7 trustee have a duty to tell the debtor if they haven't taken all the net operating loss?
No, there is no duty. I mean, this is an affirmative act which has to happen pre-petition. And I think the trustee merely, I always say, I get the platter as it is and I administer the case. He or she does not have a duty to...
No, at the end of the case,
Oh,
if the
I'm
Chapter
sorry,
7
the unused
trustee-
losses.
Right.
There is no duty to affirmatively tell the debtor that there were unused losses. It's up to the debtor to follow it if he or she thinks there's value in them. Yeah. And if a case gets dismissed, by the way, it's like the bankruptcy never happened. So you don't have to worry about the tax consequences. Now, the other aspect which one has to be extra cautious on is, and we have encountered more of that more recently, is low basis properties. When you have a low tax basis, which is a little bit of a parlance in tax language, but it's the cost of the property in a very simple version, although there can be adjustments to it. If you have owned it for several years or it has been heavily depreciated, you can have a very low cost basis in the property, and you have a $100,000 cost basis, you sell it for $1 million as a trustee. It is easy to step on a landmine. The security interest or a mortgage may be $700,000. When you realize the $1 million, the first bite on it is the $700,000 to the mortgage company. And your cash flow remaining is, in the simple equation, $300,000. And if you assume for a moment that your gain is $900,000 on the property, and your tax is, I'll just for illustration use a third, depends, it could be a long-term, non-long-term gain. You have a tax liability of over $300,000 and change on that property. And you don't have enough money left to pay the taxes. That is a death trap for a trustee. And I like to say, I don't see it too often, but I see it too often for my taste when clients call us after a transaction has been consummated. So trustees, and and this is not a lawyer's responsibility, but if you are somewhat, check mark driven, you alerted a client about it, etc., they have to be very cautious, and that's a simple example of a situation of low basis, secured asset, and your first bite is a secured party's interest. And I don't know what the tax law is on personal liability, but I always feel there is some exposure, if not for personal liability to the IRS, because the theory is that the liability rests with the estate and the IRS has to deal with it. But I don't know, maybe there can be negligent administration of the estate, etc. So one would need to think about those liability situations as well. And the key is not to get your foot in the deep water there. This happens in corporate transactions. Our firm is dealing with a case where there was a divestiture in a large Chapter 11 case of the entire business for millions of dollars. And nobody did the tax analysis at that time. And they find that, and everyone thought the company has $50 million in operating losses from the past, no problem. Back of the envelope, you're done. There are small print rules, if you will, and often referred to as the alternative minimum tax. And you cannot always use 100% of your operating losses to offset your income. There is a limitation in it under the AMT rules. And if you hit that limitation, you could find that you have taxable income, even though you have more losses than the gain on that transaction. And that's exactly what happened here. Money has been distributed to the creditors, the plan is confirmed, there's a liquidating trustee on the case, the documents provide that the liquidating trustee will take care of all the debtors' prior tax returns, which generally is a year or two if they haven't filed them, because the confirmation takes place, and then he'll do the liquidating trust tax returns. The liquidating trustee, in compliance with everything, does the tax returns for the debtor for the transaction and says, ouch, there is $3 million of tax liability.
It wasn't ouch.
It wasn't even an ouch, it was worse. This is real life, so I won't mention the case, and it came to us a day too late to do anything about it. So, we're trying to do things and trying to find creative ways to minimize it, but we all know we have to deliver the bad news. It isn't going away. So we'll see what happens. That's one example. And there are 2 or 3 others where trustees have called us after conducting a transaction, pass-through entities, LLCs, more often nowadays than sub-S's, but the same impact, partnerships. You can be a trustee on an individual case. The individual has interests in LLCs or any other pass-through entities. The pass-through entity has assets or a property. You're not the trustee on the LLC. The pass-through entity conducts a transaction of, let's say, real estate. And whatever the gain on that property is, passes through upwards, because it's passed through, to the principal of that LLC, which at that time, unfortunately, is the trustee. And that flows into the bankruptcy estate. And you have to deal with the tax consequence of that when there is no money coming to you, because there are no distributions coming to you from the LLC. And the rules on LLC distributions are, I think, beyond the scope of this presentation on what your rights are if you're a single member or multiple member LLC, and whether you, as a trustee, oftentimes doesn't have enough rights to force a distribution. And you ask yourself, what should I be doing or what should I have done? One can't wait complacently to say, well, we'll deal with this kind of an asset which hasn't had a transaction yet when it comes about. It requires a proactive assessment of the assets of that pass-through entity way early in the case to make a determination if you could find yourself in the deep end and if you need to make decisions about abandonment versus non-abandonment. You need to get out of that sooner than later sometimes. That's another pointer. And then you can have low basis properties through pass-through entities. And if you have negative capital in a partnership, it's labeled oftentimes term used as phantom income. Any transaction in it, you have no basis in that property and you first have to recoup the negative capital. So whatever is flowing up is taxable to the tune of the negative capital and you have no cash to encounter it. So this is not like, I call it the root canal syndrome when I go to a dentist. Well, if you don't fix this today, you know, it can go down, go into your jaw, and then your neck will go like that. And it's not a scare. That's not the idea of this particular presentation. But these are not to be taken lightly. They happen. Selling right title and interest, which became somewhat fashionable in the last few years. I have to tell you, I never did one. It's true. Some trustees call me, how do you deal with this? I don't know, I just never did it because I didn't think it's worth the effort to analyze the consequences before you make the decision. It was just a business decision. But if you do right title and interest, it goes with the mortgage as a general rule. And if it goes with the mortgage, there is an assumption of debt. That equates into consideration to the estate. And the moment you have that, you've got to analyze the tax consequences, not to mention the doc stamp issues. But the tax consequences can be pretty hairy. And most of these are done with carve-outs for a nominal amount. You have to, I ask myself the question, is it worth it? You know, I have an in-house team. I can tell one of my tax people, can you analyze the consequences? But I just don't care to do it. And because that's a cost to me. Either I have to hire them, and it doesn't make sense. If I don't hire them, it's still a cost. A trustee who is not an accountant will have to hire an accountant to do it. And I think those things need to be weighed. Now, I'm not here to say how business decisions should be made, but one needs to deal with that with a grain of salt. So those experiences we have encountered, and it's hard to save the situation after the fact. And we work with a lot of trustees who we now say, send it to us ahead of time if you really want to do it, so we can analyze it for you and give you some advice on what on the tax side of it. Before you do it for a $5,000 carve-out, what's the distribution to creditors? Time myself here.
So, did you want to touch on the requirements for receivers and tax?
Oh, yes, very good point. You know, we represent a lot of receivers, equity receivers, for lack of a better term, SEC, FTC, etc. Often a stepchild item is tax consequences. There are receivers who sometimes don't even hire a financial advisor because they're going along with it, without it. And when time comes, we need to do a tax return. First, they didn't realize that the Internal Revenue Code mandates that a receiver is responsible to file for tax compliance. If there are tax returns to file, if you follow the code, you have to file tax returns, which means you've got to account for all your taxable transactions. And receivers often forget that. You could have a personal injury lawsuit somewhere. Is it taxable, is it not? Is it punitive, is it compensatory, etc. A lot of analysis, not hyper-analysis, but you've got to be aware of these. But receivers typically tend to ignore the tax compliance side. Unfortunately, taxes are not always value-driven in asset recoveries, so one tends to not think much about them, but they can become a burden on the estate, and that's where the value is, because you want to avoid or minimize the burden.
And lately, the IRS has been extremely stringent on imposing penalties for not filing tax returns on a regular annual basis for partnerships. And,
That's true.
And we've had a really hard time getting those penalties abated. So sometimes in the cases, we'll decide, you know, let's hold off filing any tax returns until we get assets in a receivership case.
Yeah.
And we used to be able to get away with that, if you will. And lately, what we're finding is that the IRS is not playing ball, and they're imposing penalties, expensive penalties.
Yeah, you know, our office, I have a tax partner who is a pure insolvency tax person. That's what she does. That's all we do. We don't do regular tax. She's a guru on this, and we had a hit rate of high 90s% of getting waivers or abatements on penalties historically. Lately, in the last year, we have found, for whatever reason, we can't explain it, the Internal Revenue starts saying, we're not going to waive it. They hit our receiver clients, and anybody else for that matter, with penalties for non-filing of tax returns, because there are no transactions for a few years until the case matures. And you tend to say, let's save the money. And they say, well, and the penalties are, there's no logic, there's no correlation to value. They are flat and they run and they add up. Pass-through entities particularly. And we are encountering this on at least 2 cases right now. I have a theory of getting around them, but but it's not under the Internal Revenue Code. It's to do with victim losses versus the government benefiting first, etc. We adopted that not on penalties in Lou Pearlman, and it worked. But I'm going to transfer it to this situation. But it's a serious issue, and I'm not trying to be flippant about it. So we talk about sale of property, cancellation of debt income. There are specific exclusions in the Internal Revenue Code, and one of the exclusions, 2 key ones are, if you are insolvent, you don't have to be a debtor. If you are insolvent, debt cancellation or discharge of indebtedness is excluded from income. It's not taxable. And the easy one is if you are a debtor in bankruptcy. Any COD is excluded, etc. So one has to think about that. And the only thing is sometimes you may have other taxable income, and you got to see where in terms of timing, the COD plays into it. And to the extent you use COD, cancellation of debt income, it dissipates your other tax attributes by an almost equal amount. So if you got unutilized depreciation, net operating losses, you start invading into them to the extent that you're using cancellation of debt income. So you have to look at any planning motivations there, or how that plays in and how it affects your net operating losses. I'm going to jump out of the tax area unless someone's got any few questions now or afterwards for that matter, and take the opportunity of discussing or presenting some cases that we have been involved in and sharing some of the highlights. And this is not for propaganda purposes, to be honest with you. Louis said we'll talk about a few cases, so I'm happy to do it. And the closest to heart and to this district happens to be Universal Healthcare, which is venued out of Tampa. I am and was the Chapter 11 trustee. Now I'm the post-confirmation liquidating agent. I'm the trustee of the parent company, and through that, I undertook at that time to file a Chapter 11 for the third-party administrator company, which was wholly owned by the parent company as a single member. And that used to do the management functions. But more importantly, operationally, which is important to understand the context of the case, Universal Healthcare had multiple subsidiaries, 2 in Florida, 1 in Georgia, 1 in Nevada, 1 in Texas. These subsidiaries were in what we would loosely call the HMO business. They did not deliver healthcare services. They were an HMO provider with subscribers. I think there were over 100,000 subscribers. The revenues were gravitating and projected to be close to $5 billion. The revenue base is predominantly dependent on Center for Medical Services, the CMS Medicare agency, if you will. And it was a prominent icon in the Tampa metropolis, more so in St. Pete. Very flamboyant CEO on the company, politically savvy, I guess you could say. Very active in the circles, airplane with Romney, pictures in his offices, etc. A lead figure in raising funds for political candidates. And something went awry business-wise, and he was in the process of negotiating a sale, and the company filed for Chapter 11 with the intent of consummating a 363 sale of the entire business. And apparently, this is all predating me being appointed. There were hot negotiations. The lead bank was Bank United, $35 million exposure, and they were obviously all promoting the sale, and something wasn't coming out right at the end of the day. And there were allegations of misconduct on the part of management, mismanagement, potentially healthcare fraud. That's a DOJ issue, I'm not involved with it. But all of those allegations were there. And somehow they were having a hard time getting to closure on the sale. And close to that time, after being in bankruptcy for some months, not a whole long time, maybe 9 months or 10 months, the US government somehow raided the corporate offices. The usual thing, they yellow taped the place, laid off 700 people at the blink of an eye. The state governments in the respective states, in our case in Florida, intervened on the operating subsidiaries, which were HMO subsidiaries, and appointed state receivers there. And then with it came, after the raid, the granting of the appointment of a trustee. So I became the trustee. And the Texas and Nevada subsidiaries were not in receivership when I was appointed. They were still operating. And so, you know, my usual first day, I'm driving from Fort Lauderdale to Tampa, and I actually get a call from the receiver. He says, "Why are you coming here?" I said, "I don't know, I'm the trustee on the case." He said, "Well, we got everything under control. You don't have to come." This is true story. I was halfway on I-75. I said, "Well, I'll come meet with you, you know, we'll figure out, and I'm sure, you know, you're doing the subsidiaries. I have to come and see what's there." But it worked out fine. But that's true, that's what happened. So we come out and, you know, you have this, I don't know, over 300,000 square foot facility at the corporate office. It's pretty daunting, you know, and it's a ghost town. There's nothing there. I mean, they have computers, they have personal property, and the receiver's office has a dozen people doing their thing. And it's amazing. I was getting lost because they have like open workstations in thousands of square feet. You walk through one and you're in a maze. You don't know how to get back out of the door. But more importantly, I go there and with 2 or 3 people, and we say, "Well, walk around and you've got to deal with a lot of stuff." And she's going to talk about some very interesting items that we encounter. You know, the raid is all interesting. There's a lot of publicity on the case, mainly because the CEO's stature in the community. There's civil issues, criminal issues, FBI issues, competing interests of different creditors, the bank secured, providers. There are some providers of medical services. The question becomes, who is their claim against? Is it of the parent company or the HMO subsidiaries? The HMO subsidiaries had, especially the ones in Florida, more assets. My case had the HMO subsidiaries stock. Guess what's the value of that stock? So it took me about an hour to realize this is a huge no asset case.
Yeah.
And you know, a lot of glamour with it, but you know, glamour doesn't get you anywhere.
Yeah.
And you know, on a serious note, the problem or the challenges with cases like Universal, like Lou Pearlman, is you go in on day one, there's no money in the case. And they are not baby cases. You cannot deal with them in baby steps. Whatever you do is a major step. And the major step has an economic effect. So one has to get invested in doing something and have a hope that you'll do something for the creditors. And nothing ventured, nothing gained. If you abandon everything, you say, we just never got a dime. That is a huge thing to encounter, and mentally risk-driven, and finding professionals to get into a case of that magnitude and saying, "Are you free?" And they say, "Yes." "Can you take on this case?" "Yes." The case is free too. I mean, you know. But no, there are professionals who are committed. We hired, I think, some of the really committed, excellent professionals who put the team together. So why don't you talk about some of the stuff that we encountered here?
And I wanted to just make one other point to give you kind of some perspective on how quickly the company kind of went up in flames. Just about a year prior to the bankruptcy filing, the company had refinanced a $40 million obligation. So it was a very quick spiral into bankruptcy. And I remember the first day being on site with Sonit And he was very excited when we were driving over, to meet with the Florida receiver. That part wasn't so exciting, but we were excited about him being appointed to the case. And I think it was like by the end of that day or the following day when Sonit said, "Shit, there was no assets in this case," and your phone was ringing, excuse me. So I was one of Sonit's team members that was kind of a boots on the ground person. And once we realized there were no assets, other than there was some beautiful artwork, fakes, but pretty fake artwork, and some personal property, furniture and that kind of thing.
Johuli glass, we
But
thought.
we were excited about that, and then we realized it was fake. So after we conducted an auction of the personal property, but like Sonit said, other than that, there were really no assets. But something that we knew was very, very important in creating some assets at some point was to actually preserve all of the documents and the data of the company. We assumed, that there would be future litigation, especially with all of the allegations, et cetera. And we also knew that there were probably going to be a lot of parties wanting access to the debtor's records. And when Sonit described walking into this humongous office building, it was really big. There were several floors, there were computer stations everywhere, and most of the people by the time we were involved had been laid off, most of the employees. Luckily, because we were working in kind of liaisoning with the state receivers, they had the foresight to keep certain key personnel that we ultimately, they were very important, and we needed their help to wind down the business operations. But our focus we had a heavy focus on preserving the documents and preserving the electronically stored information. So we assembled a team. Our internal resources, we have people that have experience and expertise in preserving electronic data and information, but we also recognized that it was important, being that it was likely going to be a very litigious case, to retain an outside consulting expert to help us retain the electronically stored information. And I think that's important, to consider in a large case like this. We also were very nice and very friendly, like I say, made friends with the internal IT people. We knew that it was very important to keep them. I remember one of the first days I asked for a tour of the server room, and I had never seen anything so big in my entire life. There were hundreds of servers. There was just computer equipment and servers everywhere. It was overwhelming. And luckily, the receivers, like I said, had the foresight to retain some key people, and we maintained relationships with the IT personnel. We made arrangements with them. Almost on day one, we said, if for some reason there's not a way for us to pay you through payroll, eventually we'd like to keep, in contact with you. So if we need to call you in the future and have an independent contracting relationship with you, we made those arrangements in advance. As Sonit mentioned, the FBI had raided the headquarters of the company, and they actually took some documents and computers and things like that. So Sonit was smart enough to retain a special lawyer that specializes in criminal investigations and helped us liaison with the government so that we could be informed about what had happened, what information had been taken, so that we could document it and just keep that information for the future. Another one of the big challenges was the fact that because these were insurance companies, a lot of the information stored on the computers was HIPAA, private information. So we liaisoned with the receivers and made sure that they took the responsibility of preserving all of the patient data so that we didn't have to become involved with that process. A lot of the computers we learned as we were going through the process, and the copy machines were leased. There were hundreds of computers and hundreds of copy machines, and they were leased from, I think, 2 different vendors. And we almost, I think in the first couple of weeks of being on site, we received a grand jury subpoena. And a lot of the information that the grand jury was requesting was information located on these computers and also on these copy machines. So we had a big challenge in dealing with the vendors, the leasing companies, because we couldn't give the leased equipment back because it contained, information that was responsive to the grand jury subpoena. It possibly also contained patient-related information, And we also didn't have any money to make the lease payments. So they were highly irritated. It was a big challenge. And not to mention, the building that the office was located in was not owned by either entity that Sonit was the trustee for. Instead, it was owned by the Florida receiver entities, and the Florida receiver was hot and heavy to get out of that building so they could start marketing it and selling it as quickly as possible. So we had to come up pretty quickly with a very good plan, a well thought out plan to essentially vacate the premises but preserve all of the electronic data. And that's where keeping some of those IT people, keeping in contact with them came very helpful. We also, when we hired our forensic consultant, we made the decision to invest what little resources we had in making a forensic image of the computers. We made that decision early on after consulting with legal counsel. We knew that likely it would be important to have that in the future. And one of the unique things about this case, there were hundreds of servers, but we were able to liaison with the Florida receivers and figure out which data was patient data and which data was not patient data. So we only took an image of the non-patient data. And we actually we left that image, if you will, with our forensic consultant. And we are now entering into the stages of the case where we're pursuing certain litigation claims. And we are dealing with production requests, document production requests. So one of our strategies in responding to these document production requests, because the case doesn't really have any assets and we don't have a lot of money to spend time looking for things and finding, emails on huge computer servers, we are going to be considering just putting the people that are requesting the documents in touch with our consultant. Jerry's nodding, it's probably something you've done before, and letting them work it out with the consultant in terms of the costs of producing the record. So
it's, no money, it's very difficult.
it is hard. It's a big challenge in our cases. Not to mention, when you get a production request, and we ran into some of these challenges when we were responding to the grand jury subpoena. They're asking you to look for information, but we haven't been involved with this company historically over the years, so we really truly have no way of knowing where it's located. So even responding to production requests can be difficult, and we've invested a lot of time and money in trying to respond to the best that we can. I know we don't have much time left, so do you want to cover any other cases really quickly, or we talked about maybe discussing SMF Energy?
Sure,
Do you
I
want to
can
cover
talk
that,
a little
or?
more.
Okay.
Yeah, how are we doing on time? I know people have things to do, and
We have just about 5 more minutes, I think.
is that right?
So, or do you want to cover Evans Oil? Okay.
Yeah, I think the important takeaway from all this is, whether it's Universal or Lou Pearlman or a whole host of other cases, is proactively thinking forward as to how you're going to manage to make recoveries, and what are you going to need for those recoveries. And the foundation is the information the company had and how to distill through it and preserve it, because that becomes the platform from which you initiate lawsuits, do your investigation. You may file lawsuits. You got to respond to interrogatories. You got to respond to complaints, responses, and the entire data is in there. It's not a matter of just parking it. It's a matter of how you pull it together so that you can extract from it sensibly and cost efficiently to be able to do that. That can happen in Ponzi schemes where it's more data reconstruction driven. It can happen in non-Ponzi cases, which is not necessarily data reconstruction driven, but it is very information driven as to what is in the corporate records and corporate documents, and not just the general ledgers. The challenges of keeping the software live and active, if you're dealing with, Great Plains or whatever. How do we do some report writing later? How do we preserve it? The chain of custody issues, of course. So, those are the important foresight elements that one has to consider. We dealt with a case here. Judge Delano inherited it afterwards, I would say, toward the 11th hour, if you will. But somehow I got involved in it. I got a call. And it's called Evans Oil. It is very local to this building. I still don't know what my role was. It started off as being some kind of a monitor, etc. I did
think
what
it
the
was a
court wanted. I
facilitator.
know.
It was
It was
facilitator.
that's true. The
It
label
was
was
facilitator.
facilitator.
Yeah.
The debtor and a potential buyer, and in between a secured lender, were constantly butting heads on accessibility to information to a point of beyond frustration for the court. And nothing was getting done and months were going by. So I got appointed and the label put in the order was facilitator, and then I became a monitor after that. I assumed that was a progression. Because I facilitated the exchange and accessibility to information. They were an oil distributor here. And thereafter, there were still issues, and then the label was changed so I would be more proactively involved in the business operations. I don't know what that label is. I think they called me as Chief Restructuring Officer at that point. And I continued with it, but with the goal of facilitating the sale. I actually conducted an auction of the sale in Tampa in the Stricter Riddell offices because they happened to be representing a buyer. It was just hotly contested. It was ugly. No one was getting along in the case, which is a real shame. But ultimately a sale was consummated. People made accommodations. The bank made some accommodations and they got paid. But the essence of the project was trying to minimize the conflict between the parties and make them see through to a productive end where there would be money for the creditors, etc. The case was, after I was done with the sale and the sale was completed, there was a trustee appointed and I stepped out, and I still get some pacer stuff, and I think the trustee did a great job of wrapping up whatever was remaining, and the bank cooperated. So that was another case. It's really an illustration of the kind of different roles you can be called into play, and each one has a different nuance to it. It's fun, it's challenging, it's frustrating. No one wanted to pay me at the end of it, but I got paid. But I'm going to shift gears a little bit. Lou Pearlman was like a fraud case. It was universal, same big case, no assets. The creditors were very aggressive. There was an active creditors committee. They were always breathing down the neck of the receiver. They wanted things done their way. I wanted things done the right way. And that was always a contention, which in today's world I can talk about it. During the case I couldn't. It started off with potentially a zero return for investors, and my investors were mom and pop investors across the country. This was not the Madoff mega millionaire investors. These were not the investors in Rothstein who, it's not good to lose money, but they were deeper pockets for recoveries also. The Lou Pearlman investors were small-time investors with a sprinkle of some larger ones, and none of them, and they were all hurt. The question becomes at the beginning of the case, what's my prospect of recovery? And candidly, I have no clue. It's just going to require a lot of effort, which we put in, with constant criticism about the fees, which wasn't being paid, it was just mounting. There was nothing to pay with, so it didn't matter. But it ended up with a return which was originally predicted to be barely 3 or 4%, and we inched over 5%, 5.4% or thereafter. And I got a lot of calls from creditors late. It was 7 years later. That's what it takes to get there. Hotly contested litigation, hotly contested issues with the creditors committee because there were people on the committee who were targets. Just the way life goes, either you do the fiduciary work or you step aside. But I got a lot of calls from people. I know it's late, but I tell you that $20,000 check I got, I lost 200 here, but I really appreciate it, which was a nice feeling. So it was one of those things, frankly, in my personal view, the trustee and his professional team was truly taking the risk for the first 3.5 years until there was a light or a glimmer, and then the case became administratively even and solvent, and then it turned into something. So the point of it is really, these large cases can be great. In Florida, they are a big challenge. If they are in Delaware, they're, you have more funds to play like a textbook case. We have a case we are still working on called SMF. It was another oil distributor, which happens to be a Southern District case. I was the CRO on the case. I was brought in by the debtor. It was not going to go into bankruptcy, but it took me a few weeks to realize that they had been around for years, $250 million revenue, public company, et cetera, quoted on the stock exchange. And I found the whole business model was a fraud based on markups on the gallonage you deliver. They used to, by way of example, one of their biggest clients was the United States Postal Service. They had a contract with them. It's a government agency. They used to go with their trucks, and those postal trucks, they come deliver the mail. There is a fleet. They go to the stations, the depots, and fuel up those trucks for them, amongst other things they did as an oil distributor. And they were, now it is all public knowledge, they were marking up two things. One, if they delivered 100 gallons, they would bill 110, okay, illustratively. And that markup started with 3%, 4%, ended up getting to 33%. And then separately, they had rigged their computer software on the invoicing. And a lot of people in the company were involved with it. And the government has its own investigation going on. The Securities and Exchange Commission has the investigation going on. But these people rigged the pricing structure, so they added some service charges, and they put it in some small print behind the invoice in a faint ink, which you could barely read. They call that disclosure. So there are public policy issues, fraudulent representations.
And this was, the dollars were big, and it was like, when we got involved, I think it was about, these charges amounted to about $1 million a month in cash flow to the company. And the auditors, they had, this was a public company, so they had auditors. The auditors didn't ever catch this. They knew there was a little bit of a disclosure on the back of on the invoices for one of the charges, but there were
for the service charges, not the gallon upgrade.
Right, but there were 2 or 3 other charges, and funny enough, they labeled one of the charges the PAD, P-A-D. This was what they called it internally.
That's the pricing.
PAD.
The IA is the
Incremental
IVA,
adjustment.
incremental value adjustment.
Yeah.
Yeah. But what happens is, one is you can't do that, breach of contract, government agency, go on with the consequences of potential criminal conduct. And from a business standpoint, I went to the CFO and I said, I want you to do me a business model. If you stop doing this, which we have stopped, I said, while I'm in the CRO, it ain't happening. But I said, now I want you to do me a projection of your business model doing the right thing. And the business could not survive. And they had, I forget, a $20 million bank facility, which they had always been servicing. And I said, ouch, I'm not going to mislead this bank. And it's a bank who I'd done work with repeatedly. And they had come in when I was appointed because there was an announcement under the SA for 10Ks or the SEC announcements. So they came in and met with me and said, well, should we be hiring a financial advisor? It's an independent decision. They happen to know me from historical whatever. And they say, we're going to hang in there. You've always been a straight shooter. I hope you'll keep us posted. So I asked for a meeting with them after I got my hands around it. And I said, meet me at my office. So I could, and I walked them through it. And I told them, I'm going to tank this company into a Chapter 11. And they called a default on the loan at some point within weeks after I was appointed, which I candidly think was a great thing, because the day they were going to call a default, I was going to file a Chapter 11. And they knew that. But that gave us control over it in a whole different fashion. We liquidated the company, sold all the assets, paid off the bank 100 cents on the dollar and got them off my back so I could get on with the case. And now the case is set up, has been, in a post-confirmation trust for the litigation, which is in process.
And one of the things on the litigation, Soneet mentioned that that the company had created a software. Essentially, they wrote a special computer software to implement some of these charges. It was a proprietary system.
At corporate.
And so I think one of the key successes in this case was maintaining contact with the people that wrote the software and that implemented this program, because we have used the entire computer system
For
repeatedly
discovery.
for discovery and to respond to the SEC, to the government, and for our own lawyers to provide data and information. And the way that we did that, so you remember, is we actually picked up the entire computer system from the office and we moved it to a co-location facility, which is like a special storage facility for computer equipment. It keeps it safe and it's secure. And we have remote access into the co-location facility. And I think that's been
Yeah.
very, very
Yeah,
helpful.
and we kept in touch with the chief information officer to this day, because now we are into damage models, etc., and he's helpful. The other real challenge, and I'm going to cut it after that, because
Yeah.
if I go by that clock, I'm beyond my invited time, is when I found this, I said, oh my gosh, what do I do? I'm running a company with potential criminal consequences. So I hired criminal counsel. We went and did a self-disclosure to the Department of Justice. And we told them to let the SEC know, and we then met with the SEC. These were like not first day steps after gripping everything, etc. And we've been dealing with the SEC to this day. But those were the kind of challenges we were facing in it. Judge?
Sunny, how did you discover this markup?
How did we discover it?
We were told, when you
Oh.
were, we were told.
Yeah, you're right. That reminded me. I don't mean to interrupt you. When I was approached to be the CRO, I was approached by the CEO of the company, who had only been there
He had
4 months.
He had only been the CEO for 4 months. He
Yeah.
had been on the board for years.
Yeah, he was on the board for years, but he became CEO, and the real CEO who had been there for some time I learned later, was forced to step down. And this CEO had made some innuendos. He had given me a binder. He says, you should study this. And I was replacing him effectively as the CRO. He was resigning, etc. And how did I come to know about it? There were charts in it which were showing me, and it took me a little while to grasp it because no one was telling me the story and laying it out for me. But I still have that binder in my office.
Yeah, what he did
Yeah.
is he said, this is our revenues and this is what IA, this is the percent IA is of
He
our
didn't tell me
revenues.
IA is wrong. He said, this
Right.
is the percent IA.
And it was huge, yeah.
I mean, if you took all of that out, they couldn't pay the debt. They wouldn't have any net income. So without that, you don't have a business model. You would think, well, if you were making 10 million, maybe you can live with 6, but you can't live with it if it is way below 0. But that's how I discovered it, but I had a lot of putting the pieces together. It's interesting to know, that's why I said the rigging of the software was in the invoicing setup in the corporate, because when you really go and look at these trucks which go fueling, they have an online real-time system which is computerized there of what you're delivering. So I kept wondering, I think, how do they do this? I mean, I went and observed, I said, I want to see how this happens. So they do it, then the truck goes to their off-site location in Texas or wherever they're doing this, could be different places, and they stand by another computer, they wire it up, and then they transmit the data to corporate in Fort Lauderdale. And then somehow, when that data comes in after that fact, which means the people on the trenches have nothing to do with it. They deliver 100 gallons, that's what goes through, unless you're rigging the meter somehow. The rigging was in the corporate software where there was an up-pricing and added value to the gallonage in between that trunket. And I do know there are investigations in progress. That's how I found out. And this company was across the country. I mean, $250 million is a nice chunk of business. We made a good money on selling the Texas operations to one party. We had operations in California, was in New Orleans also, and various states. So I share that one. I mean, I've got other cases where we just did a 250-store retail operation with not a fraud. We just put them to bed softly with a going out of business sale. Concrete retails don't survive. Stats are right now saying that every retail business that had gone into bankruptcy in the last 5, 6, maybe 7 years has been a liquidation, not a reorganization. And that's what we're doing. A company called Simply Fashion in Miami with stores in, 30 states. We're done with that, and now we're just wrapping up the case. I thank you very much. If you have questions, I'm happy to answer it, but I don't want to continue.